I want to know from you guys, which of the following do you think would count as a legally binding contract in South Africa? I mean, we can click agree on a website or on an app, getting engaged, buying a parking lot ticket, and the parking lot has a disclaimer sign on it, getting a concert ticket, or all of the above. So please respond in the chat. Let me know which one of these you think is a legally binding contract. Okay. I'm seeing a lot of E. I'm seeing a lot of E. That's a very good sign. Your instincts are absolutely correct. My name's Julia. I am very pleased to have you all here today. This evening, we're going to be discussing what makes a contract valid in South Africa. And in a world where we're constantly clicking I agree on regular, we're entering shopping centers with signs outside that say enter at your own risk. We're even getting engaged without necessarily thinking about the legal consequences. It becomes very important for us to understand what actually makes a contract valid and what would your rights and remedies be in respect of these contracts that we are sometimes unknowingly entering into? Because this is something that's important not just for attorneys, but for every single South African. As a consumer, as an employee, as a business owner, these consequences become incredibly important for us all. So tonight we're going to unpack, demystify what it means to enter into a valid contract and some of the strangest situations of what a legal contract can look like. Hopefully our guest speaker is going to be able to join us, and when she's able to, then I will introduce her as well. But for tonight, let's get started. So long. So most of you said you think that all of those constitute valid contracts. And in many respects, they can. There's quite a few caveats to all of these situations. So we're going to have a look at what are the basic rules of a contract. What are the rules that a document or an agreement has to meet in order for it to constitute a legally binding contract in South Africa? And firstly, we have consensus. Now, consensus is the meeting of the minds, the fact that these people have actually agreed to enter into a contract with one another. And this sounds simple, but it has a lot of nuances to it. If you think about somebody has broken into your house and they've said, listen, you need to transfer me all of the money out of your bank account, otherwise I'm going to do X, Y, and Z. If you now agree and you say, okay, don't worry, I'm going to transfer you all of my money, you've agreed to this contract. You've agreed to send Mr. Criminal the 550 Rand that's currently in your check accounts. But did you actually agree, or were you pushed into agreeing? So consensus is a tricky one, because you can have situations where you are acting and agreeing to a contract, but you're not necessarily intending to have done so. There's an external force that's pushing you to enter into this contract. And I see in the chat, Don, you said you have to be acting in good faith. You have to be acting bona fide. And that's absolutely true. Because as soon as there's some kind of undue influence and some kind of duress, that's going to prevent the true consensus from taking place, from really showing that people have agreed to this contract. The second really important requirement that contracts need to have in order to be valid is that all the parties need to have capacity. Now, in South Africa, we assume that persons over the age of 18 are mentally sound and can enter into contracts, unless there is evidence to the contrary. And the same goes for businesses in South Africa. We can assume that people who are purporting to act on behalf of a relevant business are acting with the relevant authority. And this refers to a person's capacity whether you are a person in the traditional sense of me and you as human beings, or if you're a person in the sense of a juristic person, a company, you need to have that capacity to act. And there's a lot of situations where somebody might not have the capacity. If they're under the age of 18 and they don't have a parental consent, then if you're a business owner and you've now contracted with this person, you could find yourself in quite the predicament because you can't hold them to that contract. You can't enforce that they pay you because they never had capacity to enter into that contract in the first place. So as business owners, you need to be very, very cautious in terms of who are you entering into agreements with? Because the last thing you want is to find out that actually we can't hold this person liable because they never had capacity to begin with. Then I want to ask you guys another question, and you can post your response in the chat. Do you think verbal agreements are valid and enforceable? If I had to enter into a verbal agreement with you guys now to say, oh, I'm selling my iPhone, do you want to buy it? And you say yes. And then you take the iPhone and you don't give me the money. Do you think that that's something that we could enforce in a court? Is a verbal contract? Okay, I'm seeing Lester, you say yes, we can enforce it. Verbal contracts are valid. And that's it's a tricky one. And you'll notice that this is the theme with law, is that we have these requirements, but there's all these nuances and tricks to it, and that's where we really need to be informed. So verbal contracts can, in principle, be enforceable, but certain contracts have formalities that are required. So if we take, for example, the purchase and sale of land, if you're buying a house, if you're buying business premises, that contract has to be written. That contract has to be signed. For those of you that are married, you'd know that when you signed the marriage register and you had your contract registered at Home Affairs, that had to be signed. It had to be notarized. You had to be in the presence of a marriage officer. So certain contracts have certain formalities. But in general, if a contract doesn't have formalities, then you can enter into a verbal agreement and have it being binding. Now, I've seen in the chat, some people have said it's difficult and maybe there needs to be a witness. And what that comes down to is, how are you going to prove this? Because it's all well and good that we've now entered into a verbal agreement. I'm going to sell you my cell phone. You're going to give me some money. But at the end of the day, if I take you to court, I don't have any proof. So it is always better if you have a witness, if you have some kind of evidence of the fact that there was this verbal contract. Otherwise, what we look at is all of the circumstances that have surrounded this situation. Did the person take the phone and leave and say to everyone, oh, I got a new phone? Because that might be evidence of the fact that, okay, cool, this contract's gone through. So we take into account all that other evidence when we're looking at now proving whether or not there's been a verbal contract. And I see, Karen, you have joined us. Hello, welcome.
Well, that was some struggle, but maybe that's linked to my age. Lawyers do not know everything. Welcome, everybody.
Thank you so much for joining us. And just to introduce you to everybody here this evening. So Karen is an accomplished conveyancer, an attorney, a notary with over 20 years of experience. And she runs her own law firm and works daily with a whole host of contracts. So it's great to have you here this evening, Karen, and to discuss some of the things that we might be overlooking in our day-to-day lives.
Interesting. Yes, I'm privileged to join you today.
Thank you. So I've been chatting to our colleagues on the call here about consensus and capacity and formalities. And we're going through, well, what are the requirements to make a contract valid before we can even look at, all these wonderful nuanced situations that we don't really expect to be contracts. And we're looking at, well, what actually makes a contract valid? So we've discussed consensus, capacity, and formalities. And now we're looking at legality. I don't know, can you give us an example of where legality becomes really important for a contract?
Well, in my field that I work in every day is conveyancing. So you will go and look at statute to see what's the requirements from statute side for your written agreement. And I specifically say now written agreement because the Alienation of Land Act stipulates that no agreement that relates to immovable property is valid if it's not in writing. So when you get, say, for instance, an estate agent and you have this discussion and you're so passionate about this house you want to buy and you say, oh, I'm willing to pay R1 million, and I'll take it to my seller, and we go back to the first essentialia, and that's meeting of the minds. You have meeting of the minds what the price is concerned, but the Alienation of Land Act stipulates it must be in writing before it's a valid contract. So even though you agreed on the price and you are both very excited, there's still no contract because nothing is valid if not in writing. So that is just one example of statute putting extra formalities on the table.
Absolutely. And statutes informing legality and common law informing legality also becomes a big concern. And to pose a ridiculous example, if someone was to hire a hitman and they've now transferred 10,000 Rand to the hitman to say, hey, Mr. Hitman, please take out this person who dinged my car in the parking lot. And then the hitman's like, okay, great, I'm going to take your 10,000 Rand, and then does nothing about it. I mean, what can we do about that? We can't do anything about that.
If you do something about it, you will be in jail.
Absolutely. And the contract has to be lawful. And that's a very extreme example. That's a very dramatic example. But it's the same as that if you are entering into, think of when it was COVID and people were sneaking around buying the odd bottle of gin.
Yes.
That contract would have been completely invalid because it's illegal.
Yes. And Julia, if you take it to something very interesting, and that's you're entering a mall, for instance. Again, on the legality side, they put this huge sign on to say, we indemnify us against all liability whatsoever nature, and also contracting out of negligence. But now our question, is this legal? Because from common law side, you have the duty of care from the supplier side. So you've got from common law side your protection of the consumer, and there's the word, your Consumer Protection Act. So it's not only common law, it's your act, your statutes again, putting a specific burden or obligation on the supplier to say you may not contract out of, say, your liability to duty of care. So they can sort of force you into thinking that you have no rights. But is that not in essence fraud or illegal to do something like that? To make me believe that I have no rights, yet there's statutes that will protect me. So that is so interesting, and it puts like the glasses on your vision to what is at play here. Is it's not only to intimidate people, but is that not what they're trying to do? They try to make you think you have no rights. Hopefully, you'll not institute any action against them. But that is fraud. That's not the reality. That is not true.
Absolutely. And we've all seen those signs. You go to Gold Reef City, you enter into any shopping mall, you enter any privately owned space other than most people's residence. There's a sign that says, enter at your own risk. We will not be held liable for any loss and injury. And the fact of the matter is that can't prevent them from all liability.
Yes, because the Consumer Protection Act specifically Section 48(1), if I remember correctly, stipulates that a supplier, if it's his normal course of business that he's busy with, can't contract out of his liability. Maybe he can tell you, listen, you enter at your own risk. But now in the parking garage, there's this huge hole in the pothole in the path because in the runway. Yesterday, some pipe burst and there's this huge gap. I mean, it's not something that you would easily see. You were there yesterday. It wasn't there. So you come around the corner, but no cones, no warning signs, no duty of care to prevent harm of the public. So if the cones were there and you just thought, oh, whatever, and you go into that big hole, then you didn't take care. So it's like balancing of what is your obligations, but I have obligations as well. And that's, as we say, you not only have the glasses of the supplier on or the consumer, it's what is reasonable in the specific scenario. And that is what the court will test at the end of the day, is what is reasonable. Previously today, we looked at a case where McDonald's was sued by somebody who slipped on a floor. And surely they can't contract out of their negligence because they had a duty of care to the public. But now the question arises, okay, that yellow sign, be cautious, slipping floor or wet floor or something, was that there? If it wasn't, then McDonald's didn't take duty of care. If it was there, did I adhere to the warning? What did I do? And that is the balancing act that we need to apply at the end of the day, is what is reasonable for me, what's reasonable for a supplier.
Absolutely. And then it becomes a matter of, you don't want, as a business owner, to expect that you've put that sign up and now you're absolved, you're fine, you don't need to worry about anything. And you also don't want to be, as a consumer, to see that sign and now think that you can't have any sort of relief if you are injured due to a premises and their negligence. And I think it's exactly what you've said. It's what's reasonable in the situation, because as much as law is about what does the law say, it's very much about how is the law interpreted to that set of facts. And if you're going to twist your ankle, just walking up a small step entering into McDonald's, then like me, you've got bad joints, and I'm sorry for you, McDonald's is probably not going to be held liable. But if there's a massive oil spill that they didn't put a sign up next to, then we're saying that you can still hold them liable because you can't contract out of negligence, essentially.
Yes, exactly. And then you get something like a courier company. They don't actually know what you put in your packet, yet you want to insure it, say, for instance, for 15,000 or 20,000 Rand. Sometimes we send original title deeds of property from Cape Town to Joburg. I mean, really, to think that you put your proof of ownership in an envelope and you just give it to somebody, it costs about 3,000 to 4,000 Rand to replace that with a new deeds office copy. So I asked the courier company, can I please insure this document? And they say, no, we are exempt of liability should we lose the packet. And that's the thing of duty of care. So they must do the minimum, what's required of the courier company to keep your packet safe. But you must also know you're taking a risk by sending it when you know they don't give you the option of insurance. But I don't know if we're allowed to say any courier company names, but let's say we investigated the terms and conditions of this online acceptance of terms and conditions. And one specific courier company very clearly explained that they have first a duty of, say, consumer protection side, or from the consumer protection side, to clearly identify what you will be, say, accepting or what you will indemnify them of. And they specifically give you the paragraphs in this agreement. So it's not this lengthy thing that you just want to get to the I accept part. They say, please look at paragraph 22 because there's something you should know. Please look, and that was very informative. And I think if you go to court on something like that, they would say they did act reasonably to say that you should read this, but specifically the following. And what's further interesting is you cannot just scroll down and accept. You must actually go through the whole document, sort of to, okay, even if you didn't read every line, you went through the whole document. So they put a lot in place to show that they did their duty, or they had that care of listen, look out, and be careful. And then only if you feel comfortable, tick the box. So you get all sorts, and by knowing that requirements, you know if you see something, wow, they are taking a chance here, or wow, that's been properly advised or negotiated.
Absolutely, because you think, okay, as a company, as a business premises, I've got my sign, but let me take out my personal liability insurance as well, just in case
Yeah.
something does happen. But then even that company needs to make sure, well, what does their contract with their personal liability insurer say? And what are they actually going to cover you for? And are they going to cover you for negligence? Because that might be something that's then excluded.
And again, with the insurance, they say you've got your due care obligation. For us to cover you, you will have to prove that you took great care or due care to protect. If you didn't, you're not going to claim from the insurance. But in court, that would be an excellent question to ask people who wants to rely on the indemnities. Is, okay, sir, can you please just confirm to the court if you actually have liability insurance? And
Yeah.
if they say yes, then why? Why? If you think you've got no liability, why do you have the insurance? Because you are fooling me now. Yeah, so very interesting.
And I see Valerie's asked a question in the chat, which is quite a good scenario of, would a golf course be responsible for a windscreen damaged from a golf ball, even though there's disclaimers? And I mean, if you think about the amounts of golf estates, or even just driving past a golf course, what happens in that situation? They've told you it's reasonable in their line of business that there's going to be some golf balls flying around. So can they then just get away with that?
I think what you would look at is again that if I stress the due care part over and over again, apologies for that, is okay, did they put some screens up? To say, okay, for most of the day, then the balls will go here or here or here. But no, in the odd chance that some newbie is practicing or playing at the golf course, the ball just goes over the fence, but that was unforeseen. So it's not something foreseeable that I should have counteracted on, or just it was unforeseen. And in the constitution of that golf course, or the estate homeowners association's constitution, they would say, listen, we took this precautions, but in the unfortunate event that this should happen, please make sure you have your own insurance to cover that. So yeah, that is very interesting. Well, very good question.
We did a case analysis on this a couple of years ago, and I forget the case. You guys can all forgive me. There's a lot of case law rattling around in this brain. But there was a situation where it was exactly that. It was a house on a golf estate, and the balls kept on coming into the garden, kept on hitting out the windows. They'd replaced like their third window, and eventually they were enough's enough. And in that situation, what they found is that the way the golf course and the estate had been designed was that that house was always going to be at the end of a fairway. It was always going to be in direct line of those golf balls. And in that situation, we can see there was no duty of care. There was no, let's not put a house there. And in that situation, you could absolutely then claim because it's negligence in terms of the design. And it's like you say, Karen, it's where it's something that's unexpected and it's unusual, and we couldn't have prevented that. That's where those signs of enter at your own risk are really helping companies and really saving them and saving them from the Julias who take one step and, almost break an ankle where it's actually not their fault. It's an unexpected occurrence.
Yes, yes, and the reasonability at the end of the day, because if something happens, then I mean, blood pressure rises. People are so angry and they just see red. So the reasonable, almost like aftermath of the whole event is needed, and I think that's where I mean, us as attorneys, we don't have very good reputations, but I think that's where the attorney comes in, because the client is on the one side and you advise the client to say, yes, I know it's so unfair, it's terrible, it's this and this and this, and I hear you, but let's go and look at what does the law say, what's the newest cases decided on this, and then you advise your client of reality, and then your client can communicate better with the other party, because that party will also go to an attorney who would say, this is a long shot, you can't get away with this, so you should settle because this can be a huge thing, and because the reasonableness are explained, the clients usually calms down and they say, okay, I'm still furious, but I hear you. No essential, all 6 essential, weren't met, or it's not a legal agreement that we entered into, or it was not clear, there was no clarity, there was no consensus of the minds, and then that negotiation start to say, okay, where are we now? We must meet each other smack in the middle, halfway, and what you are not 100% in the wrong, but I'm not 100% in the right, so where are we gonna meet each other?
Absolutely. And that basically sums up legality, because legality, yes, there's certain things that are outright illegal. We know we can't hire hitmen, that contract's never going to be valid. But things that we might be overlooking, like trying to contract our way out of our own negligence and our own duty of care, also render contracts to be invalid. They cannot be enforceable in that regard.
Yes, yes.
And then the next one.
Sorry, yes, a question from the audience side.
I see Lester was asking, what about a motor vehicle that's left overnight at a service facility and then it gets stolen? And they had all the big disclaimer signs, in their workshops and reception areas. But at the end of the day, the vehicle got stolen out of their service facility. And it's a very interesting one. And the same inspection needs to be done. What was promised? Did they say there's going to be a security guard on site? Did they say, oh, you can leave it here, but listen, this place is abandoned in the evenings. It's at your own risk. You need to start looking at everything that is said and everything that is written to determine whether or not there's a duty of care. Because if you park your car outside of my house, I don't have a duty of care to watch your car. But if you came to me and said, hey, listen, I'm going out, would you mind just keeping an eye out on my car? And I said, okay, I'll go out once per 30 minutes and check that your car is still there. That's all I've agreed to. That's it. So it would depend on that.
That is the reasonable test. For you to park your car on the outside of a residential building or house, that is maybe the reasonable person. But if you park it at a service center, that's not the reasonable person. That's the reasonable expert on what they are doing. And if you take on business and you take out the engine, can I come and collect my car to put it in a safe place for you to continue your work tomorrow? No. So it's not reasonable for me to do anything to keep my car safe. And that's why there's umbrella insurance. So that is that sort of literally the umbrella going over the service station to say, whatever happens inside this service station, That is the liability that the service station accepts and that their insurers accept. So once, many moons ago, my mom took her vehicle for a service. And I mean, she is pedantic with her vehicles. Oh my goodness, you must sit up straight and you may not drink anything. I'm thirsty. No drinking in the car. And then at 12, they called her and said, "Man, there was a little accident." So they, and here we get to legality again, the illegal impact of something on a situation is they put somebody into a vehicle that's automatic, that he doesn't have a driver's license. So he just took the car from here to there, but he has never driven an automatic car. So there's one pedal missing and he got confused and he ran that car into a ditch and it was like smashed. And oh my goodness, talk about blood pressure, you see. So, and at the end of the day, they must take responsibility to say that whatever happens underneath this umbrella, that was negligent of us to put somebody like that behind your wheel. That's not the agreement we had. Duty of care? No, that's not duty of care, and they had to pay. So that starts to be a rhythm, a test for reasonability, but they are experts in their field and they should have known. Yes.
Absolutely. And that standard is different. A reasonable
Yes.
expert and a
Yes.
reasonable person are two very different standards. And I don't know if you guys remember, there was quite a big court case in America a couple of months ago about a lifeguard who tried to save a child and saved the child, but then the child was really sick afterwards. And it says lifeguard on duty. And the standard of what was that lifeguard meant to do in that situation and how was he meant to prevent that risk versus what the standard would be if I was on the side of the pool are two very different things, because there's more of a duty to care on that professional, on that expert, as opposed to, your standard bystander. So that also, it makes a big difference in terms of what is reasonable and what is legal, because depending on your role in the situation, you could have greater expectations
Yes,
to
exactly.
prevent harm to somebody else's rights.
Mm.
And I think as businesses, it's a cautionary tale, because while we might not all be lifeguards, it happens across every business where you have a greater duty of care than the public.
Yes, and statute is so important to remember that, because it's not only the general common law duty. If you, say, for instance, work in construction, then what's your duty of care when you go to a working site? I mean, what do they do? I know I've got people that work in construction closely related. So when they leave for a big job, they say, "Listen, all the paperwork in order." Such a short sentence. It's like, yes, but do you know what care you must take for this to actually pay out? And then statute again, how does that impact on that? Because they've got occupational health and safety. They've got, you see, extras. It's sort of refining this broader duty to exactly what you must do. And if you don't do that, then your insurance is not going to mean anything to you. So, and then I draw up tick lists and things like that. So I call it toolbox talks. In the morning when you eat your little breakfast and you sit on your toolbox, you must read this and tick that you know what your responsibilities are for the day. So what is the care that I must take as a normal person? Just give me the hammer, give me this, or the engineer that must say, yes, the pipe is now finally installed, open the water. So that is again the rhythm that we hear.
Yeah, you can't contract out of occupational health and safety. You can put up all the signs in the world that say enter at your own risk, but at the end of the day, if the construction company did not comply with their occupational health and safety, they are going to be fully liable for that damage. And I think that's where it's really important that we don't just take these contracts at face value. We don't just see them and say, oh, there's nothing I can do about this situation that happened to me. Because often there is something that can be done about this situation where people weren't meeting the standard that they needed to operate in. And one of the other essential elements for a valid contract is possibility. Now, when I imagine possibility, I always go to the extremes. I always say it's like contracting for the moon. If I contract with somebody, I'm going to pay you 20,000 Rand. Please make sure that I have a beautiful full moon on my wedding day. That's not possible. It's completely impossible for anybody to do. So contracts have to be possible, and we need to consider that possibility in terms of who are the people in the contract. Can they deliver on this promise that they've made? And could anybody deliver on this promise that's been made? So that's one of the others.
Yeah, it's so important to follow up on that. Again, in my industry, people sort of just believe everything other people tell them. It's when, say, you do a conveyancing, an agreement of sale. So your client comes in, you say, okay, Mr. Purchaser, you must now pay 2 million Rand into my attorney's trust account. According to the contract, it must be done within 4 days of acceptance of the contract. So you've got your offer, you've got your acceptance, your meeting of the minds, the terms are there. And then they basically just say, okay, yes, what's the bank details? And I get very nervous because I always think from the other side or with the other side in mind. And I'm like, you're not even going to ask proof that I am actually an attorney registered with a valid fidelity fund certificate to say that I may practice. And they're like, yes, but why would I ask that? And that's, again, that's your duty to take care of yourself, because you only have cover from the Legal Practice Council side for fraudulent actions from the legal fraternity side if you checked up on the credentials. So, yeah. So I'm like, okay, here's my fidelity fund certificate. Here's this. Go and check on the website. Go and do that due diligence. And okay, but they're more than willing just to go with the flow. But if there's a problem, then everybody wants to sue. So, yeah, so that's the thing of, just be very careful that you also always go and look first at yourself to see possible. Is it possible for this person to execute on this? Because what would make this possible for this person? To be an attorney and to be a conveyancer. That's an extra thing. You must go and look up on the website. Is this just attorney? Is it a conveyancer that can execute on this contract? Do they have the certificates to keep me safe when I have a claim? So yeah, very, very interesting.
Absolutely. You have to know what is possible for the people that you're dealing with and that specific contract. Because we take it for granted that when somebody is promising us something and they purport to be a professional within their field, that what they want to deliver is possible, but it might not always be actually possible, and that could then render the contract completely invalid.
What do you think about receiving a quote, for instance? If you're asking somebody to build you a house, and then the person comes back and say, yes, I can build it, it will be 5,000 Rand. Then obviously, wow, is this going to be possible? Can you honestly keep this person to this agreement if you know the possibility is not going to be ticked? I mean, it's impossible. You can't even buy how many bricks for that. So he just wants the deposit. So you should have foreseen that there can be a problem. So now you can't go to the court to say, you must get my money back because I didn't do what I didn't use my brain. I was not cautious to look out for myself on possibility, only the mere possibility of the actual action. Yeah.
Sometimes deals are too good to be true. And that is that your party to the contract might not actually be able to live up to that contract that you are relying on them to do.
Yes, yes, yes.
And I think I want to steer this conversation now in the direction of clicking I agree. Because I mean, I clicked I agree today. I booked the honeymoon and said, "Oh, I agree." You know, we do it for everything, whether it's Netflix, it's online banking, it's
So,
everything we do. So if I click I agree, am I now legally bound?
yes. Well, again, if I say I agree, did I read? Did I acquaint myself as to the content of what I agreed to? So, but I think in a way we can be a little bit, I think, feel safe that there is so much obligation, legal obligation on the other side, that should I not read so carefully, um, then somewhere I'm going to be protected. Even if I didn't do my due diligence, then surely the Consumer Protection Act is going to grab them by the throat, or there's going to be some statute to say you had extra obligations not even to offer this to a client because you know it's illegal, or you know it's not clear, if you know it's not possible. So yeah, I don't want to say feel safe by not reading, but there's, if you advise the customer, the actual supplier, you can tell them you must be very careful not to put clear terms, because although they tick, they most probably going to have a foot to stand on, either by statute or by common law, to say that you didn't do what you were supposed to do. So you can't blame me, put all the blame on me. I don't know. What do you think?
I think you've mentioned something really important is that we rely on it, especially when it's a bigger company. When you get your accept the new terms and conditions for your cell phone upgrade, you know, you rely on the fact that, well, Samsung, Apple, Vodacom, they've sent this now to all of their millions of customers. So surely them and their team of lawyers must have done it properly. And then I think because of that reliance, we don't necessarily read those terms and conditions that are going to bind us. But at the end of the day, your acceptance is made in a variety of ways. You know, if you have seen that sign that says enter this car park at your own risk and you've gone in to the car park, you've accepted that contract. If you click I accept the terms and conditions, it doesn't matter that you didn't read every single word. The company that sent you that information is relying on your acceptance. They're not there to physically watch you read all the terms and conditions. So they are relying on the fact that you've done your due diligence. But what happens when it's not that clear? When you're expecting that my iOS upgrade is just going to come with some cool new features, but actually now I need to pay 12 Rand 50 per month per every SMS I get. Is there a way to at least protect ourselves against that, considering that we're relying on companies acting fairly?
Yes, and I think that's where the consumer protection will come in, to say that, do you have a cooling off period? Say, for instance, you clicked on everything and okay, you've got the phone, and then you see it's unfit for the purpose. So that's one of the bases that you can cancel the contract, to say it's unfit for the purpose. You can buy a car, second-hand car, and when you get it, there's no engine in it. So never mind the false presentation, that, or the misleading, deceiving information they sent you. It is unfit for the purpose, and you've got your 6 months warranty for that unfit for the purpose, and you can return without any questions being asked. So these, I think you will again fall back on statute to say that, listen, do consumer protection give me 7 days to cool off if it was direct marketing and things like that. So yeah, you will again go back to statute, and most probably the consumer is going to be in a position to say, no, thank you. I don't want it anymore. But we can't
Yeah.
rely.
And it's a good cautionary tale for businesses and people who are operating in the decision-making function of the businesses, because you have an obligation as somebody who's sending out that electronic contract or any contract really to specifically alert customers to any terms that might be unusual or unprecedented. You have that obligation to make sure it's super, super clear. So
Yes.
where you get a ticket or a terms and conditions and you have to go through 50 different web pages to see your terms and conditions, and at the bottom, tiny, 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 in a font that nobody can see with a microscope, you have it in light gray written there. That would not constitute as being valid and binding, because they need to be clear. They need to be readily available to the consumer. And you also need to be able to access those terms and conditions before clicking agree, which is really important, because you'll see some of sneaky click agree here, but go to the next page for the terms and conditions. And that's not allowed. It might send you on a link before you click agree, but you have to have access to those terms and conditions before consenting to the contract.
And a very interesting thing happened in the week. My article clerk did a little investigation as to this readily accessible terms and conditions. So I went to, let's say, a mall, and there was this sign and to say that you are bound by our conditions or bound to our conditions, but you must get it from management. So you have to enter actually. And he walked down and he asked Information Center, do you have the terms and conditions? And they just frown and say, please proceed to management. So you're walking down, you can break a leg or slip on something and you don't even know what the terms and conditions are. And even when he spoke to them, they weren't that sure. It's like, must it be in hard copy? Where is it? So that will definitely be something that will not benefit them when that goes to court, because it's you already entered, so they can't say, yes, by entering you accepted our terms, but I had to enter to get to the terms and still I couldn't get it. So this, what's the hallway then? It's the it's the your liability area until I know what my liabilities are. So very interesting. I saw something coming up. What is what will happen when there's undue influence signing contracts? And it's almost the same as when you don't have the right facts. Okay, so that is, you ask the question, if I knew what the real circumstance are, or if I had the chance to say no, so if I was not like overpowered by you, would I have entered into this contract? Or no, never, ever? Or if you buy, say something, would I have paid less? Would have been in a position to know all the facts? Or yeah, so if there's undue influence, then that can make a contract just invalid, because there's no meeting of the minds, because that undue pressure, I didn't agree, I didn't consent, it wasn't out of my free will, you forced me. But in another instance, if you presented the wrong facts to me, oh, this is a 4-bedroom house, oh, it's actually only a 2-bedroom house, it's like, wow, it's way smaller. If I knew this, I would never have contracted with you. So yeah, invalid if it's undue force, but you will have to prove it. And that's not always that easy. Hopefully you will have a witness that that can testify to that.
And I think that's kind of where we find ourselves in the current South African landscape, is that there's an over-reliance on one another. There's an over-reliance from businesses that, oh, the sign I put up is going to protect me. There's an over-reliance from consumers to say, oh no, this company is contracting with loads of people. They'd never put something funny in this contract. We are taking things very much at face value rather than spending the extra 2 minutes to go and walk to management's office and say, hey, can you give me the terms and conditions, and actually inform ourselves on what our rights and duties and responsibilities are in respect of many situations. And as we wrap up this session, I wanted to mention one particularly fun one is the breach of promise.
Oh,
Because it's something that almost everybody does at one point in their lives. They get engaged and you think to yourselves, oh, this is a beautiful, happy thing. We're going to get legally married at some point, and then I'm going to have to share half my assets or half my liabilities with this person, depending on our property regime. But do we actually consider that now breaking off that engagement would potentially lead to some, some financial liabilities?
yes, exactly. And the other question is, what can I claim? Because I mean, this is I don't really particularly like or love this person. I will break it off sometime, but this very wealthy person I can maybe claim something from him, or I can just act in a manner that he breaches his promise, and then I can claim for future. No. So the court came back on that to say, no, 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 no. You can't claim on the hope that you would have married in community of property, or the hope that he would be a wealthy person whenever the marriage would come to an end. But what you can actually claim for is the actual cost. If you call off the wedding 4 days before the actual event, somebody spent a lot of money. And yeah, so you can claim for that actual losses. So guys, girls, before you get onto your one knee in December with the beautiful moon at the back, yeah, be forewarned, there might be some consequences.
Absolutely. And I mean, we've seen legal precedents for it where these fiancés, they're engaged, they're happy, the engagement is broken off, and she spent 13,000 Rand on a wedding dress. The down payment for the wedding was 10,000 Rand. Renting of the horse and the carriage and whatever you do, it adds up to actual financial loss. And it's something that, again, we take for granted as not necessarily being a legally binding thing. We're thinking with our hearts, we're thinking with our, I want to spend the rest of my life with you, and not necessarily looking at, oh, but if I left you tomorrow, I'm going to have to pay you for all those expenses that you've made thinking that we're going to be getting married. And some of them can really rack up to quite a healthy amount. But like you said, Karen, at least it's not as bad as it used to be, because previously you were also able to claim for the emotional damage. And have you now told your family, and did he post it on Facebook that he's no longer marrying you, and all of those other beautiful things? Now it's kind of chalked down to what is the actual money that you lost, and anything else you're going to have to find a very clever attorney who can work it into some defamation of character.
That's so true. So, and the big question, not the big question, will you marry me, but can you keep the ring? Do you want to keep the ring? What if the ring costs? So, yeah, on that high note, more questions than answers.
And that is the beauty of law, is that there's so many questions, but the purpose of this session was really to show everybody that we have a duty to ask those questions. We have a duty not to take things at face value and say, oh, there's nothing I can do about this situation, or I'm totally safe. We have a duty to inform ourselves so that we can take that duty of care and we can protect ourselves and we can protect our interests and everybody else's interests.
Very well put. Yes. Fantastic. Thank you so much. It's been so informative. And yeah, all the best to those people who must challenge everything they see.
Every single thing. And guys, if you have any other questions for us, please feel free to post them. And we'll also have some access to the chat after the fact. And I think very importantly, I want to highlight to everybody that law is relevant to everyone. I mean, we don't expect you guys to all go and get LLB degrees and LLMs, but to have a basic understanding of your rights and of your responsibilities, it not only makes us ethical South Africans, but it also helps us operate in the business world where we're not putting ourselves at risk. And that's why this is incredibly important to inform ourselves. And I think thank you guys to everyone who joined, because you've taken that step of wanting to inform yourself. So you're on the right track. Thank you so much, Karen, for the session and for giving us your insights. It was wonderful to have you.
Wonderful. And dare to speak up.
Dare to
Yes,
speak up, everybody.
yes, all the best.
Have a great evening, everyone. Thank you for joining us. Bye.
Okay, bye.